Okay. Good afternoon, learned senior advocates of Nigeria, friends and colleagues. Today is day 2 of the civil litigation training being organized by the Institute of Continuing Legal Education. And it's actually the 3rd session. And today our speaker will be looking at the topic, pleadings. Our speaker today is Uncle Ken Mosey. I call him Uncle Ken because I've known him by reputation at least for a very long time, right from when I was a student. So for me, he is a legend. He has been around for a long time and his reputation indeed precedes him. Uncle Ken Mosey, a senior advocate of Nigeria, qualified as a lawyer as far back as 1978. He graduated from the University of Lagos in 1977. He practices in Benin. He's the managing partner of Ken Mosier and Co. His areas of specialization include civil and commercial litigation, arbitration, election petitions, appeals, banking and finance, administrative and constitutional law, litigation, energy, oil and gas, real estate, public interest litigation, international contract financing, and labor law. Ken Mosier is a barrister and solicitor of the Supreme Court of Nigeria, was elevated to the bench in 2010. Was elevated as senior advocate of Nigeria in 2010, and also a notary public. Please permit me to introduce today's speaker, Mr. Ken Mosier, senior advocate of Nigeria. Uncle Ken, thank you.
Thank you very much. It is indeed a pleasure and honor to be part of this, except that uncle is not part of the name, just Kenneth Mosier. But I thank you anyway to be here. Today, the topic area is on pleadings. And yesterday, Mrs. Mia SAN gave a talk, or should I say, set out some teasers, as she prefers to call it, on the preliminary but foundational issues of taking instructions and reviewing facts and materials from prospective litigants, at least in the case of prospective claimants or plaintiffs. Then upon counsel making a determination that there are viable prospects for a successful litigation, you move to stage 2. And at that stage, Mrs. Akredolu yesterday also admirably handled this portion of it. Now, preparation of pleadings is stage 3. In the case of a person on whose instruction the fresh action is being initiated. This is because the statement of defense and the kindred processes are also pleadings. But the preliminary issues to be considered in that case are materially different from that, in which you would if you were like a claimant or a plaintiff. Because in that case, an action will have been filed by the adverse party or parties, and the factual basis of the claimant or plaintiff's claim of entitlement to the reliefs claimed will have been set out therein. We shall examine this issue later when it comes to the preparation of the pleadings from the perspective of the defendant. We were also reminded yesterday about the ethical obligation of counsel to deal with his client honestly and advise him aright. Counsel should not supplant his interest for that of his client. I say so because now we have situations where counsel sometimes, as a consequence of looking for concluded high court cases, they opt to initiate what will be an obviously hostile proceeding by an expeditious but inappropriate manner. Sometimes we find them initiating such cases by originating summons rather than filing writ of summons, which will eventually necessitate the preparation of pleadings based on the perception that they can expeditiously get to the end of it and have one more high court case to add. That is hardly appropriate. I say this because I have come across ridiculous cases where chieftaincy matter was initiated by originating summons. Another one was involved in a mercantile commercial issue in which lawyers or our firm and another have been holding meetings, we have been discussing, and suddenly they file originating summons asking for one oblique portion of the agreement to be interpreted. Clearly, it was clear that at that point, and I told the colleague as such, he was no longer thinking of his client, but he was thinking about himself and the necessity for him to get one more case to add to, we know, the current applications. Now, we'll start by looking at pleadings. Black's Law Dictionary defines pleadings as the formal allegations by parties to a lawsuit of their respective claims and defenses, with the intended purpose being to provide notice of what to be expected at the trial. That is the classical definition of what a pleading is. Now, there are different types of pleadings because it is a generic term and it includes the statement of claim, the statement of defense, reply, counterclaim, set off, further and better particulars of pleadings. Then it also includes, in the area of electoral jurisprudence, you have the election petitions, and you have the respondents' replies to petitions. In matrimonial causes, you also have petitions and replies, which are files, because these are matters that essentially contain the material facts and the evidential basis upon which a claim is sought to be made, or in which an initiated action will eventually be defended. Now, but in strict legal sense, pleadings will not include the writ of summons or the endorsement that's expected to be on it. Now, the function of pleadings are numerous. Firstly, they are to help to define and delimit with clarity and precision the real issues in dispute or controversy between the parties, upon which they can prepare and present their respective cases during trial. They are also intended to prevent springing of surprises on parties at the trial. The general rule is that parties and the courts are bound by the pleadings, as admissible evidence is also guided by the pleadings. Pleadings are useful guides, particularly the plaintiff's claim, as to a determination of the course of action, which will in turn impact on an ascertainment of whether or not the courts before which the matter is pending have jurisdiction over the subject matter. So pleadings constitute records of issues raised and determined between the parties. So it also forms the basis of certain statutory pleas, like plea of estoppel, parem judicata, in subsequent actions. These are all matters that are derivable from pleadings. And there are also guides in determining who bears the burden of proof on the respective issues. These are matters that are provided for in Section 131 of the Evidence Act. So they guide parties as to the proper approach to your opponent's case. Now, the next thing I want us to consider are the contents of pleadings in relation to the rules that govern pleadings. Generally, the rules of court prescribe the contents of pleadings, although sometimes
Then I say you appear to be frozen. Do please exercise patience while we try to rectify this. Dear delegates, apologies. It appears that Mr. Kemozi, Senior Advocate of Nigeria, has technical issues. We're trying to see if this will be sorted out shortly. I acknowledge the presence of past President of the Nigerian Bar Association, Mr. A.B. Mahmood, Senior Advocate of Nigeria. You're welcome, sir. And I also acknowledge the presence of Mrs. Abimbola Akeredolu too. You're welcome. Mrs. Senior Advocate of Nigeria, welcome. Mrs. Ma Essien, Senior Advocate of Nigeria, you're welcome. Thank you very much.
Okay, I think I managed to get back. Hello?
Yeah, we can hear you now.
Okay, sorry for technical hitch. It popped off. I got bumped off for a while, I guess. Okay, I'm sorry about that. All right, I was just about to state that there are some exceptions where matters other than material facts must of necessity be set out in the pleadings. For instance, if the matter has anything to do with any customary law, Islamic law, foreign law, these are all matters to the extent that the impact on the claim to be made during trial, they have to be pleaded, irrespective of the fact that it may not be material fact, but then it will be material fact for purposes of the determination of the rights that the party claims thereunder. Then, of course, if there's a point of law also to be relied upon, that has to be pleaded, because this will not now be violative of the rule that only material facts and not law should be set out in the pleading. Then the facts in issue between the parties, those are the facts, but not the evidence to be pleaded. Then the next thing we must set out in the pleading are your reliefs. They must be specifically stated and fully and in details in the statement of claim. So a pleading like the plaintiff's claims as per the writ of summons, that may be lazy pleadings, which should be avoided. Now, if you consider the format or the formal requirements of a valid pleading, it will start, this may sound a little pedestrian or rudimentary, but we'll state it anyway. The court heading, suit number, parties, the capacities, that will be the first thing that will set out in your pleading. Then you consider the body and then the prayer sought. There should be the description of the process, that is to say whether it's a statement of claim, statement of defense, or statement of defense and counterclaim, or reply and defense to counterclaim, but it must be stated with adequate specificity such that all those who have connections with that particular lawsuit will not be left in any doubt about what the process actually is. Then it should be divided in numbered paragraphs containing ideally separate statements or allegations of facts. Now, I have had cause to witness in court, and I thought that was taking it to a ridiculous extent, where in a pleading, erroneously listed paragraph 1, 2, 3, 3, 5, it should have been clear that the second 3 was a misstatement of 4. And the opposing counsel filed an objection that the pleading should be struck out, that it wasn't numbered in paragraphs. I thought that was rather laughable, but he did. So we have to be careful in the final presentation to ensure that these things are regularly and properly done. Then the facts must be stated in chronological order in which they occurred. That will make for an easier presentation of your case, and it will make for a better understanding. And then you can harmonize your presentation with your pleading, because it's important that you carry the court and your colleague, the adverse party, along with what you're doing. Then if you want to plead your facts, it is advisable and ideal that the facts are pleaded positively, precisely, distinctly, and briefly. Now, avoid passive pleading, obscure and ambiguous statements. For instance, if you avoid pronouns to avoid ambiguity, you use descriptive titles of few names. For instance, the plaintiff, Mr. John Doe, and then subsequently you refer to the Mr. Robinson, so that one is not left in any doubt about who we are talking about. And in pleadings, we should try as much as possible to be consistent in the nomenclature we deploy. So we should not use different words to refer to the same thing in different paragraphs. For instance, in one paragraph, you don't refer to a document as a lease. In subsequent paragraphs, you refer to them as tenancy agreements. So there must be consistency in order to make for clarity of presentation and understanding. And of course, the rules make it mandatory, most rules, that when you express figures and dates, the numbers, they should be in figures. So 500,000 naira is 500,000 naira figures, rather than writing it out in words. And then, of course, you must ensure that at the end of it, the pleading is properly signed and dated by a legal practitioner, so that we don't have this situation where you find a non-legal practitioner signing a writ which will impact on its validity. So we must avoid the situation where a writ is signed by Anko, or you find several lawyers, as has become fashionable, particularly in electoral matters, where you list a host of lawyers as appearing, And then there's a problem trying to figure out who among the several names there signed. But I think this has been ameliorated now by the use of the stamp, because the stamp ought to indicate who actually signed it. But before now, it was an issue where people failed to tick the particular name of the counsel that signed it. Then the pleading ought to also contain an address for service of the parties, which should be legibly printed so that the issue of service should be easy for the court bailiff to deal with. Now, the next thing to think of must be matters which must be specifically pleaded, depending on the subject matter of the litigation. Generally, as I stated earlier, all matters that will tend to take the opposing party by surprise ought to be specifically pleaded. But some of these matters are covered by rules of court, and some have evolved over time as a matter of practice, but they have been validated by judicial decisions. They will include matters like illegality, commission of crime or fraud, limitation of action, defamatory words and particulars of publication, equitable maxims and special pleas, for instance, negligence, res ipsa loquitur, estoppel, laches and acquiescence, doctrine of standing by, undue influence, release, rescission, lien, accord and satisfaction, waiver, special damages, customary law, foreign law, and Islamic law, as I stated earlier, written agreements or other documents, insanity, statutory immunity and exceptions, unenforceability of a document, traditional or family history or title of ancestors, bona fide purchaser for value without notice, set-off conditions precedent, denial of right of other party to the claim as executor or trustee or representative capacity, mortgages, forfeiture or relief from forfeiture. Those are matters that, if intended to be relied upon, they are matters that ought to be specifically pleaded, whether in the statement of claim or the statement of defense, depending on who one is represented. Now, the statement of claim is usually the first pleading that is filed, and it supersedes the writ of summons, but it must be confined to the cause of action that is endorsed on the writ. Now, we had stated the contents or the format of the statement of claim. After the initial statement as to the court, the parties, and all that, there's usually the introductory averments. This is a statement about who the parties are, their businesses, and their connection with the transaction, which is the subject matter of disputation or the dispute, and the fact that the defendant and the subject matter within jurisdiction. These are matters that you usually set out acts from which station of evidence. Then there'll be the body of contain the statement of ex facie, disclose assertion of the defendant's violation of that right.
You're muted, sir.
Okay, it's out now. All right. You can hear me now, I hope.
Yes, we can.
Hello.
We can hear you.
That's fine. All right. Now, the body of the pleading is also not expected to contain matters in anticipation of what the defendant will file in an answer to the claim, perhaps in an attempt to purposely destroy in advance an anticipated defense. This is what, in the case of Shell Petroleum Development Company against Burutu local government, is reported in 1998, 9 Nigerian Weekly Law Report, part 568 at page 318. The court referred to as leaping before coming to the styles, so that you can wait and achieve the same purpose when the statement of defense is eventually filed, and you have a right to file a reply to respond to whatever new issues will have been put in by way of this defense. So, but to file anticipatory pleadings may be considered inappropriate because you don't attack a defense that is yet to be made. The final portion of the pleading ought to contain the reliefs, which are crucial to the determination of the jurisdiction of the court. And then you must also have an eye on the materials with which you intend to establish your claim of entitlement to those reliefs. Basically, these are the things that you set out to achieve when you are preparing the statement of claim. Now, if a new client comes to you with processes already filed by the adverse party, in which event the pleading that will become material for consideration will be the statement of defense. Then all you have to do first is to scrutinize the statement of claim and all the processes filed, because now there are accompanying processes that must come with it. There's the question of front loading. So you, after, of course, you will have followed the injunction of my colleague yesterday, Mrs. Tessia. You will have settled the issue of your fees and collected, sorted that side of it out. Then you look at the statement of claim, scrutinize it properly, look for serious objectionable errors capable of constituting sufficient grounds to terminate the case. Then you fashion out what legal defenses may be available to the client. I'm assuming in this case that, yes, it will eventually result in continuance of the litigation process, because at times, if you look at it and factually your client or the defendant has no sustainable defense, you also are ethically bound to so advising. And occasionally, it would even be better to initiate discussions, as we were told yesterday, and to see whether you can get himself soft landing. But in a situation where you think he has a sustainable defense, technical defense is a good defense, because we tend to run away from it, say, let's get on the merit. But I am one person, the first thing I do is to look for a technical defense, see whether I can take out the case in the minute and take it out early. Why should I spend 5 years defending the case if I can take it out with issues, errors capable of constituting sufficient grounds for terminating the suit? In this wise, things like the statute of limitation, is the case still sustainable? You have to look at that. Then yesterday, we dwelt a lot on the question of things like absence of or failure to comply or indicate due compliance with some mandatory condition precedent. For instance, the issue of issuance of pre-action notices. So if these things are not there, you can leverage on it to take steps to have the matter terminated at that point, which will avoid an unduly prolonged litigation. But in the event that everything appears regular on the face of it, you have taken all the instructions, you have determined the defenses you want to pursue on behalf of the client, then the thing to do then would be to prepare your statement of defense. So you have to look at the allegations and the facts that are specifically set out in the statement of claim, and you must traverse them specifically, point by point, and not generally. And it may be better to do so in the same order in which they are set out in the statement of claim, by not only denying them seriatim, but by also pleading your own contrary facts, and said that, well, documentary evidence, that documents are documentary evidence which may not necessarily be pleaded. But I have a different attitude to that. Yes, you can rely on that where there are omissions to plead some, or some come into being after you have filed, or they were not made available to you at the time you did. But if you have all these documents, my attitude is that it's better to overplead than to underplead. So I usually prefer to plead these documents and then avoid any problem of having to contend with objections on whether they were pleaded or not pleaded, and whether they can form into the documentary evidence of material facts pleaded. All those can be avoided if the documents are pleaded with sufficient specificity. Then in answering a statement of claim, sometimes we have problems with making admissions. If you have to admit any portion of the claim, because that's why, if it's obvious, it's against your client, if despite it, you can still make out a sustainable defense, you admit and specify the paragraphs and the facts that you are admitting. Now, if you are admitting any particular part, you must specify specifically the ones you are admitting and the ones you are not admitting. If you are also admitting partially, it is ideal to indicate that the extent to which you are admitting any facts, and then you set out those facts that you are not admitting. Because sometimes you find that due to omissions or inelegant pleading, certain pleading may, without meaning to, you now go and admit very damaging portions of the adverse parties' claims. So we have to be very careful about the way we phrase admissions in particular. Now, there are some exceptions to the general rule that all material allegations in the adverse parties' pleadings must be traversed. For instance, if matters of law are of the plaintiff, you don't need to join him in traversing it by stating the contrary position of the law also in pleading, because the insertion of that pleading in the first place will have been inappropriate. Then the issue of damages and their quantum, for instance, it may be sufficient to deny that the damages alleged occurred or that the quantum is there. But unless you want to make an admission as to the BTO of damages that has occurred, it is better to just traverse the thing and leave the plaintiff to begin to prove the damages that he will otherwise be entitled to. But in all cases, a traverse must unequivocally deny or answer to the substance of any allegation without being evasive. Then it is also advisable to avoid what will amount to a mere denial of the letters of the allegation rather than the substance of the issue. For instance, a plaintiff claims that a defendant may be in an action founded on thought that he flogged his right hand. And then a defendant comes up to deny that he flogged the right hand, the plaintiff's right hand, with a cane. It's better to just say, listen, he did not flog it, whether as alleged or at all. That covers the field. but we have to be careful that in an attempt to be you don't limit yourself unnecessarily by tying yourself to the language deployed by the claimant in his own pleading. Now, I'm trying to see how we can cover the field in the areas pointed out in the write-up, because I have an eye on the clock. Now, generally, the opening paragraph in the traverse in the statement of defense, where we say you deny, save and accept as is hearing after expressly admitted, the defendant denies every allegation and all that. Sometimes we erroneously fall back on this in the belief that this is enough to controvert material and important abatements in the pleading, but it is not factually. The effect is that, yes, it generally notifies the plaintiff that you want him to prove the allegations in the claim, but they are not sufficient traverse of specific allegations made against the defendant. Now, the other points I try to look at are the issues of confessions and avoidance. Here, a defendant admits the facts alleged, but he proceeds to avoid the effect of the admission by alleging new facts, which will give a different legal consequence to the admission and effectively constitute a defense to the claim. For instance, now a defendant may admit that he hit a plaintiff, for instance, but he now asserts that he did so in self-defense. You admit the allegation, but then you justify it by stating the facts, which will constitute or amount to a defense on your behalf. Now, this appears similar to the pleas of laches, accord, and satisfaction or waiver, where the defendant may admit that the plaintiff once had a cause of action, but he contends that the cause of action has now abated or been lost. Now, they are not exactly pleas of confession and avoidance, but the effects are basically the same. But all such matters must be specifically pleaded in separate paragraphs of the statement of defense. Now, where ordinary traverse will be sufficient, it is advisable not to converse and avoid because of the attendant collateral matters which the defendant must prove, instead of leaving the plaintiff to prove his allegations. Now, the next point we want to look at are objections on point of law. Now, the rules of court provide for the manner in which this may be done, but they are generally to be specifically pleaded, and they are usually expected to be taken expeditiously, usually at a point before the trial. Now, they are referred to really as proceedings in lieu of demurrer. Now, certain rules prescribe timelines for raising objections, particularly on the issue of assertions of want of jurisdiction. But some of the jurisdictional objections are usually things like asserting that the plaintiff lacks the local standard, that there's a complete failure on his part to fulfill conditions precedent, that the action is statute barred, or that the defendant is protected by immunity, or that the writ and or statement of claim discloses no reasonable cause of action. These are the usual platforms upon which you can launch an attack on point of law against the claim of the adverse party. Now, in some jurisdictions and under some rules, if the application is not made timelessly, then it has to wait until the end of the case, in which event the court will be expected to determine the issue along with the judgment, on the understanding, of course, that that issue will be resolved first. Then if it is upheld, then the courts are still enjoined to go ahead and express an opinion on the merits of the case in case the appellate court does not uphold their decision on the preliminary objection. Now, the other point we want to look at where we have to put in any kind of set-off. This is applicable where the claim is usually for a sum of money. So it is a monetary claim by the defendant relied upon and pleaded as a defense and set off against the plaintiff's monetary claim. Now, the parties affected must be the same. Otherwise, the defendant cannot plead a set-off. For instance, if the plaintiff is suing in a representative capacity, the defendant is not entitled to set off a debt which the plaintiff owes him personally. Now, the plea is a shield and not a sword, and his life is determined by that of the plaintiff's claim. So that where the plaintiff's action is terminated, the issue of set-off also abates. A set-off does not necessarily mean that the plaintiff's monetary claim is admitted, but it only means that if the plaintiff's claim succeeds, his realizable claim is reduced by the value of the set-off. Now, judgment is usually entered for plaintiff in the sum by which his claim exceeds the set-off where same is upheld. It is possible to claim as a set-off an amount in excess of the plaintiff's case. Now, by the authority of the First Bank, the case of First Bank PLC against NBA-ICLE Limited, 2015, 3 Nigerian Weekly Law Reports in part 1445 at page 21, a set-off should not exceed the plaintiff's case. Otherwise, it is better for the defendant to file a counterclaim. So usually, that is the advisable thing. Then we'll consider the counterclaim. Now, this is a cross-action raised with a statement of defense by a defendant who claims to have a cause of action against the plaintiff. It is not merely a defense, but it's an independent action of the defendant against the plaintiff. It does not necessarily have to arise out of the same transaction, nor be predicated on the statement of claim. And it may survive the termination of the plaintiff's claim because, of course, it is on its own a separate and independent action in the eyes of the law. It must, however, be of such a nature that it can conveniently be tried together with the statement of claim by the same court. Now, the court where the plaintiff's claim is filed must have jurisdiction over the subject matter of the defendant's counterclaim. Otherwise, it will be better for the defendant to file the separate action in an appropriate court. It must be properly headed counterclaim, as it serves as the defendant's statement of claim as against the plaintiff. It is subject to the rules of pleading and must continue with the numbering started in the statement of defense. It ought not to commence with a fresh numbering of the paragraphs serially, although there is case law now on the point that it will amount to undue technicality to dismiss a counterclaim which was separately headed as if it's a different process. But there seems to be the older decisions on the matter tend to suggest that if you now file a separate process headed counterclaim rather than continuing with the statement of defense, that will be taken to be an irregularity. Before then, a strict application of the rules has resulted in such counterclaims being declared to be incompetent and refused. Now, apart from pleading the allegations of fact generally, there must also be a plea by incorporating the phrase that by way of counterclaim, Hello?
Yes, we can hear you now.
Okay, I was told that I was out by my colleague here. Okay. We must have that the defendant's cause of action in the counterclaim must have arisen as at the date or time of the issuance of the writ of summons. If we see the case of Gowon against Ike Okong, it's in 2003, 104 law report LRN 10 and 17, where the Supreme Court refused to allow a counterclaim, which accrued, the cause of action accrued after the date of the issuance of the writ of summons, so that it must also contain a relief. Otherwise, it will not be held to be a valid counterclaim. Now, the difference between a counterclaim and a set-off is that whereas the counterclaim is an independent action of its own, a set-off is not. A counterclaim is a sword which attacks the plaintiff, whereas the set-off is a shield which defends the defendant. A counterclaim can be both a sword or a shield if it can also be pleaded as a set-off. But a counterclaim may not necessarily be monetary, but the set-off is usually monetary. A plaintiff must also file a defense to a counterclaim, otherwise it will be taken as having admitted it, but the plaintiff is not expected to file a separate defense to a set-off, except of course if he raises new issues, and then you can seek leave of court to file processes in response to the said new issues. Now we're also to look at third-party proceedings. Now, this is more of an issue under parties to an action or under interlocutory application, but since it's listed under pleadings in this course, I will try to provide a small explanation on the concept. Now, this is a special procedure by which a defendant to an action or a plaintiff who is a defendant to a counterclaim applies to join a third party who will otherwise be a stranger to the suit as his defendant on grounds of having a claim against him for contribution, indemnity, or other relief connected with the plaintiff's claim against the defendant. It is in effect a new suit between the defendant in the original action and the third party, whereby the third party becomes, if it was at the instance of the maybe counterclaimant to a defendant, becomes his defendant. Now, if the original party is asserting a claim against a third party, which is somehow related to the claim for which the plaintiff has sued him, you can also apply for leave for that person to be joined, and the court, if persuaded, will do so. Now, the third party is not usually joined as a co-defendant, but as a third party, as he has nothing to do with the other party, that is to say the plaintiff, as far as the pleadings are concerned. The aim of the procedure is to avoid multiplicity of actions, and the application is usually made by a motion ex parte supported by an affidavit and written address. If the application is granted, then the third party notice will issue. Now, the types of cases where third party proceedings usually apply are contracts, joint tortfeasors, cases where courts think that the third party will bear eventual liability, cases where defendant claims indemnity against a third party, or cases where defendant claims reliefs connected with the original subject matter, which is also substantially the relief claimed by the plaintiff, sorry. Now, let's also look at another type of pleading, which are usually the replies. A reply is the pleading filed by, usually say, a plaintiff in response to this defendant's statement of defense. It is intended or is usual for it to be utilized to answer to new issues raised in the statement of defense, or to make new admissions he may be disposed to making. Where a plaintiff fails to file a reply in answer to new issues in the statement of defense, he is deemed to have admitted them and cannot be allowed to use evidence in rebuttal at the trial. It is not in all cases that it becomes necessary to file a reply, as in where there are no new issues raised in the statement of defense. And that's why the courts are usually reluctant to allow a plaintiff, for instance, to have a second bite at the cherry by seeking to improve on the presentation of his case by filing further pleadings, except, of course, he followed the route of filing an amendment to his process. So if there is no genuine necessity for filing a reply, the courts will almost certainly not allow it. Now, it is also unnecessary to file a reply for the sole purpose of denying allegation made in the statement of defense. So if all one wants to say is to say you are denying certain paragraphs in the statement of defense without more, that will not be a permissible reply, because of course there's also the principle of employee joinder of issues. Now, when you, so all material statement of facts in the statement of defense are therefore deemed to have been denied and put in issue. Now, if a statement of defense contains a counterclaim, the plaintiff must file a defense to the counterclaim, because in that event, there will be no implied joinder of issues, as a counterclaim is a separate and independent action of its own. And where the plaintiff makes a reply or a defense to counterclaim, he must caption it appropriately as, say, a reply and defense to counterclaim. Now, the style of pleading in a reply is by specifically, because facts are traversed in a reply differently from the manner in which they are traversed in a statement of defense. Specific allegations of fact in the statement of defense are traversed, for instance, in this manner, that the plaintiff joined issues with the defendants of paragraph XYZ of the statement of defense. Then you go ahead and you state the material facts that you seek to canvass at the trial in presenting your own, what will be the defense to the issues raised in the counterclaim. Now, the time for filing and service of pleadings. The time for filing the statement of claim is determined usually by the rules of court. But now, the writ of summons in virtually all the rules makes it mandatory for the pleadings and accompanying processes to be filed along with the writ of summons. So you'll find that the statement of claim, your witness statement, the front-loaded documents, and all that are expected to be filed along with the writ of summons, so that once the writ is eventually issued, they will all be served along with the same. Now, the statement of defense, the various rules of court also stipulate when they may be filed. Usually, they range from 30 days to 42 days, because we also have to take into consideration the provisions of the Sheriff and Civil Process Act, so that for those that are outside jurisdiction, you take into consideration the time for service. Now, the reply and defense to counterclaim. The rules of court also stipulate when such may be filed, and in some cases when such may be served. Now, where the statement of defense contains a counterclaim, the time for filing of the defense is subject to the rules applicable. Then, in some cases, the expression used by the rules are answering a defense as distinct from filing a defense. But the defense is necessarily answered by a reply. So my own position is that it refers to the filing of a reply and not necessarily filing of a defense to a counterclaim. Now, one of the items listed is the extension of time to file pleadings. I think this may be more appropriately considered under Part B of the courses which deals with interlocutory applications. So I plead that I'll be allowed to pass on this one. Then the next one is the close of pleadings. Now, upon service of any of the pleadings are deemed closed upon expiration of time allowed for filing any response as provided by the rules. Where no statement of defense is filed after the time provided by the rules for filing same, under certain rules, then the pleadings are deemed to have closed. But if a statement of defense is filed, pleadings will close upon expiration of the time allowed after service of the statement of defense on the plaintiff if the plaintiff fails to file a reply. Where the plaintiff files a reply to the statement of defense, pleadings shall be deemed closed at the expiration of usually after 7 days after service of the reply by the rules in most jurisdictions. If, however, there's a counterclaim and a defense to counterclaim is filed along with the plaintiff's reply, pleadings shall be deemed closed after the expiration of time for the defendant to file a reply to the defense to counterclaim served on him, and he fails to file a reply to that process. Now, where the defendant filed a reply to the plaintiff's defense to the counterclaim, then, of course, it is after that and after the expiration of the 7-day period that it will be to have closed. Now, after the close of pleadings, parties are not allowed to file and serve any more pleadings without the leave of court. The rationale behind this, of course, is that there should be an end to the exchange of pleadings. At the close of pleadings, then issues for determination can then be identified. Now, what is the effect of the default of pleadings? Under various high court rules, if the defendant defaults or omits to file his pleading upon being served with the statement of claim, the claimant may, after the expiration of the time allowed for filing the defense, depending on the nature of the claim, he may apply for one other final judgment where the claim is for a ascertainable debt or liquidated money demand. Then he may apply for the matter to be set down for trial, where damages are to be ascertained by evidence or where the claim is made for declaratory reliefs, because declaratory reliefs are not grantable even an admission of the adverse party. So if the party defaults to file pleadings, you must still call evidence to establish your entitlement to the declaratory reliefs you are claiming. Now, the judgments will usually be final and valid, but they may be set aside upon application on grounds of fraud, establishment of non-service of any of the processes filed by the adverse party, or you raise the issue of lack of jurisdiction by the court. Now, the amendment of pleadings, usually parties are bound by their pleadings, and evidence as to facts not pleaded, they go to no issues. And the evidence by parties are usually restricted to pleaded facts. However, sometimes there may be an omission to plead matters that may have been within those made available to the counsel upon being briefed, or matters germane to a fair consideration of the facts of the case may come to light after pleadings have been filed. And in some cases, during the examination of witnesses or cross-examination, some evidence may be elicited in respect of pleaded facts which may be beneficial to the party concerned. And of course, errors can always be corrected as long as the adverse party will not be prejudiced thereby. So the object of the court is always to decide the right of the parties and not to punish them for mistakes of their counsel in the conduct of their cases. So in such cases, it may be justifiable to apply for leave to amend the pleadings to set out any of this correction, and sometimes to harmonize your pleading with evidence already adduced. And in appropriate cases, the court will favorably consider such an application. Now, under various rules, amendments may be made by either party at any time or any of the following times. Sometimes at any time before the trial, during trial, but before judgment. The Abuja High Court rules are like that, or at any time before the close of case management conference, and not more than twice during the trial, but before the close of the case. So it's generally advisable in every event to make your application for amendment as soon as practicable, because the earlier the application is made, the greater the chances of success. Because if, for instance, a plaintiff has closed his case, a defendant, it may be inappropriate to allow a defendant to amend to introduce a matter that was available to him during the pendency of the adverse party's claim. Then you wait for him to close his case. Then you bring in an amendment knowing that at that time, it may probably be hard put to traversing those new matters you seek to bring in. Now, this amendment is not necessarily restricted to the trial court, because at the appellate stages too, parties may seek for the court's indulgence to amend your pleading even at that stage. But then the conditions of course are stricter, because the amendment must be consistent with the evidence adduced at the trial, and it will not seek to make a new case for the parties. Section 16 of the Code of Appeal Act and Section 22 of the Supreme Court Act may be valid for consideration at this point. In very rare cases, a court, if the rules of the court permit, a judge or a judge in chambers may also amend any defect or error in a proceedings, suo motu, as may be necessary for the purpose of a just determination of the question in controversy. For instance, in the case of Afolabi and Adekunle, 1983, it's Supreme Court 98 at 117. The Supreme Court suo motu amended the capacity in which the plaintiff sued and gave judgment accordingly, as the court found that to support the amendment was already on record. My view is that it will, however, be prudent for the court or judge to invite parties to address him on the issue before amending, in order for the court not to give the impression that the court has descended into the arena of conflict. Now, I tried to look at when amendments may be refused. For instance, if it will present a completely different case or cause injustice to the other party, if the amendment application is brought mala fide, or if it will necessitate the hearing of further evidence. That was the case of DICO against Ibadan Southwest Local Government, 1997 to NWLR Part 486 at page 249. Or if the requested amendment will not cure the defect identified and which is said to be the basis of the application, or where it is inconsistent and the court determines that it is useless or immaterial, or if it will amount to overreaching the adverse party or an abuse of the court process. These are circumstances under which the court will most likely refuse an application. Also, if we seek to introduce elements of fraud or defense of justification for the first time after the case had closed. Now, the form and procedure for amendment. Counsel usually brings the application for amendment by motion of notice, supported by an affidavit and written address, which should disclose cogent reasons for the amendment sought. And the proposed processes for amendments should be exhibited. It varies in the attitude varies from one jurisdiction to another. In some jurisdictions, you are expected to set out the schedule of proposed amendments. You must exhibit the extant process in respect of which the application is made, and you must also exhibit the proposed amended process. In some jurisdictions, it is sufficient for you to put the proposed amendments and highlight the amended portions. I've seen some cases people do that by underlining or by emboldening the portions. So what is acceptable will depend on the rules and then the practice in the particular jurisdiction. But usually at the end of the process, the rules of court usually make it mandatory to insert an endorsement to the effect that it was amended on a particular day pursuant to the order made and so and so and so. Now, a fact that an issue usually arises on what the entitlement of the adverse party is with regards to filing consequential amendments in response to the issue introduced. Now, the ideal thing is for the counsel to make that application when the ruling is given permitting the amendment, ask for leave to file consequential amendment, and that may be granted. And in some cases, you just file it without leave of court, but the consequential amendment must be limited to responding to the issues introduced by the amendment. Otherwise, if it is in excess of the issue, then you have to seek leave of court to file your own fresh application. Now, if there's a failure to amend after the court's order, in some jurisdictions, all you will do is that it will attract default fees, but in some cases, in some other jurisdictions, it will be deemed to be void unless the court grants you an extension of time to do so, which you must apply for. But the effect of an amendment is that the pleading relates back to the date of the original process amended, and it takes effect as if it was the original pleadings filed. The case of Mobile Nigeria Limited and IAL is on point on this. Now, counsel has a duty to disclose necessary facts that will enable the court to determine the real, these are matters, the prescriptions of the RPC, really, so that you can just look at the duty on counsel at section 53. Counsel need not plead false facts. So if counsel is under an ethical duty to avoid the use of perjured or false evidence, you must not participate in the creation or preservation of false evidence or forgeries. You must not counsel or assist a client in illegal or fraudulent conduct. You must not knowingly make a false statement of law or fact in any of the processes you prepare and you file. And then counsel, if you consider the case of your client to be hopeless, you have a duty to inform the client accordingly. Those are the prescriptions of Rule 4 of the RPC. Now, you should not advance a claim or defense that is unwarranted upon existing laws, except where such claims for defense can be supported by argument in good faith for an extension, modification, or request. I'm out again. Oh my goodness, why do I keep going out? Huh?
You're not out, though. We're seeing you and hearing you.
It's my
it must be his system.
It's my colleague here that keeps telling me, I think his own system goes out and he tells me I'm out.
Yeah, he's the one that's out, not you, sir.
You are hereby barred from rendering your opinion. All right, so now counsel may, I think what you should do really is that you cancel the summary of it, is that counsel takes full responsibility for whatever cases he files or defense, and you will not be absolved from bringing a questionable action or arguing questionable advice on the grounds that you are only following your client's instruction. Rule 30 emphasizes that the client is an officer in the temple of justice, and you must not do anything or act or conduct yourself in a manner that may obstruct, delay, or adversely affect the administration of justice. These are my thoughts on the various points set out for me to look at, and I hope you will find this useful in future conduct. Thank you for the opportunity.
Thank you very much, Mr. Ken Mosiah, Senior Advocate of Nigeria. Very illuminating lecture. The comments are coming in and people are quite excited. Thank you very much, sir. I'll now invite my colleague, Ms. Nta Ediken, to conduct the question and answer.
Okay.
So Nta, please.
Okay. Good afternoon, Leonard, sir.
Yeah.
So I'm just going to read out the questions from the chat box.
Okay.
So just take it as we go along, and we have just I think about 17 minutes for this segment. So Dr. Christopher is asking, in a scenario where 2 or 3 counsels are seized of the same matter before the court, draft the pleadings, and unbeknownst to them, one of them has a defective stamp and seal, affixes the same to the pleadings and files at court. Would I be correct to object to the pleadings be invalidated, incompetent, and a nullity?
No, the pleading will not be just because there are issues with the stamp and seal. It is if the counsel that signs is not a legal practitioner whose name is on the roll that the pleadings will have an issue. But if it is because the stamp and seal has some defects, as long as it is not signed, for instance, with the ANCO, because that is really where the problem comes. But once you ascertain that he is the signatory, he is a qualified lawyer, his name is on the roll, regardless of the error in stamp and seal, it will fly. After all, the courts have held that even where you have fixed an expired stamp and seal, it will still be okay. So that will not invalidate the process that he has filed as long as his name is on the roll and he signed as his person. Yeah.
Okay. So Judith is asking, where there is a precondition not met, like pre-action notice, do you as a defendant counsel appear and verbally object or state it in your pleadings in the statement of defense?
You have to state it in your statement of defense. Then whether you file it as a preliminary objection or whether you wait and use it at the end of the day will be a judgmental call to be made by you. I may raise the issue because the courts have taken a position on the effect. It was, I think, either it was Mrs. Essien or Peredolu that addressed on it extensively yesterday. So if the pre-action notice is not issued, whether the thing is fatal to the process or whether it will be considered to be an irregularity which you can waive. So it is advisable to raise the issue, but then will it be a bar, assuming it invalidates the process, whether the fellow can come back, give the appropriate notice if he's still within time, and refile the action because it will not have been determined on the merits. So you have to raise it in your pleading and then apply and set it down and have the process taken out for that because it's fundamental.
Okay, thank you, sir. Destiny asked the same question, so I guess that has been answered. Ora Maxwell is asking, where the claimant fails to endorse an address for service in his originating processes, does this anomaly affect the jurisdiction of the court?
Well, you have to be up and doing to ensure that your process is served. Because if the process is not served, then of course the matter will not progress. And if the process is not served within the stipulated time, the writ itself will lapse. Because if there's no address for service, as an initiating process, it is expected to be served within an indicated time. Usually it is 12 months. So if it is not served within the period because you failed to provide an address for service, ordinarily the registrar is not expected to accept such a process for service if it is not endorsed with the address for service. But in the event that you successfully file same, and then the bailiffs will be handicapped because they will not serve your process, and it will just remain in the bowels of the court. And after the validity period, the process will lapse. So the only way you will go, you have to go back to court to apply for leave to renew the writ, and in which event you have to supply an address for service. Otherwise, the bailiff will still be incapacitated and will not be able to serve your writ. So whichever the case is, it is expedient that you include the address for service on all the parties that you take to court.
Okay, so Olumawa is asking, can a counterclaim still stand where the writ of summons is defective and struck out?
Yeah, the counterclaim can stand if the main claim has issues or is struck out, because in the eyes of the law, the counterclaim is a separate and independent action of its own. So the fact that the statement, the initial claim has been struck off for whatever reason, will not affect or terminally affect the counterclaim. You can still continue with your counterclaim. Yes.
Okay, so Opayami is asking, what is the fate of a counterclaim premised on a claim that was eventually adjudged to be incompetent ab initio due to failure of the claimant to sign same, taking into consideration that a counterclaim is a separate claim entirely from the original claim?
Yes, my view is that if the original claim for whatever reason is adjudged to be struck out, either for want of competence or that the plaintiff or claimant did not succeed in establishing his entitlement to the reliefs he's claiming. But in this case, the question is that I assume if the initiating process is void ab initio because it was improperly executed, but the counterclaim, which is a separate and distinct action, was commenced, paid for, the counterclaim, in my view, will still subsist regardless of the fate of the main claim. Because sometimes you will find that if you were to be otherwise, by the time you check out all the processes, then the counterclaimant may be irreparably prejudiced because by then his claim may have become statute barred. But the fate of the counterclaim is not necessarily contingent on the successful prosecution of the main claim. No, that's why they are separate and distinct.
Okay, someone is asking, please, what is the designation of parties in third-party proceedings? Are they called plaintiff and defendants?
Oh, you have plaintiff, you have defendant, then if you now bring in a third party, it will be so designated. He may not be a party in the original action because he may be a complete stranger to the plaintiff, for instance. But if the circumstances that will make his joinder expedient, he will be joined as a third party and at the instance of whosoever brings him in. He can come in at the instance of a plaintiff, he can come in at the instance of any of the defendants. As a matter of fact, a defendant can ask for a co-defendant for it to issue against a co-defendant. For instance, the first defendant thinks the third defendant is obliged to contribute where they are sued jointly and severally. You can ask that that be done. So the designation of the third party will be as such because the leave to issue a third party notice will usually be given if made out by the person applying, who can be either the plaintiff or a defendant.
Okay, sir. So Agbo is asking, please, can a document be pleaded to in reply to statement of defense when such documents were not pleaded in the statement of claim?
Yes, if it becomes an issue or if it arises from the pleading in the statement of defense, in which event the claimant or plaintiff will have a right to file a reply. And in the reply, if that particular document will avail you of a defense to the assertion of the defendant, yes, it can be pleaded. But it has to be relevant to the new issue raised in the defense and not as an additional pleading to the case already made.
Okay, so Niran asking, is it a must to file a defense when there is a fundamental preliminary objection on point of law to be filed?
It's usually expedient. The point being that even if you think that the case, the objection will be well made out, the current judicial thinking is that because of the possibility of a further appeal, it's expedient for the party. Sometimes, otherwise, we'll be talking about demurrer, which is ruled out. The rules about demurrer. That makes it expedient for you to file your pleading and to raise the point in your pleading. And then you apply to court for that point to be set down for determination, as opposed to just filing it, which will otherwise amount to a demurrer, which has been abolished. So yes, you have to file your pleading and raise the issue before you file it.
Okay, Zubaru asks, can someone file a notice of preliminary objections twice in the same court, same matter after the first one failed, then you discover that there is no reasonable cause of action and filed another preliminary objection for the second time?
There is ordinary, provided they are not on the same issue, there's ordinarily no reason why you should not raise different issues, but parties are not encouraged to file objections instrumentally or in fragments. So if you have all the issues, you don't stop proceedings by bringing them out one after the other. You are enjoined to raise all the objections that you want, provided they are not mutually exclusive. So ideally, you should not. But what you may not do is to repeat the same objection. Perhaps you think you have a different and more novel argument. You may not present it again as distinct from the argument or earlier considered by the court. But if it's in respect of a different issue completely, then there will be no bar, except that, like I said, it is not expedient for parties to be raising these objections instrumentally, as it were.
Okay, so Yaya is asking, where after close of pleadings and the issuance of pretrial conference form, the defendant sought to amend his defense and counterclaim, is the claimant entitled to costs as of right, having filed a reply?
Well, costs in all events is discretionary. So there's no question of being entitled to cost as of right. It's always at the discretion of the court. But the court will accord recognition to the fact that due to the act of the adverse party, you are put to some expense, which will otherwise have been avoidable. And the court may, on that grounds, award some costs to accommodate the extra expenses. But your own antecedent conduct will also come into play here, because if you too have been delaying proceedings and costing, the court may sometimes say cost in the cost, or may not be favorably disposed to the notion of awarding cost. But in all cases, it must be understood that the award or refusal to award cost is discretionary, and it's at the absolute discretion of the judge. And that is one award that you may not be allowed to appeal against. Award of cost is usually not one that you can appeal against, no. So, but it's discretionary in all cases.
Okay, so Daniel is asking, please, what's the effect of a statement filed after the claimant has closed his case or about to close his case?
May I have that question again? Statement filed?
What is the effect of a statement filed after the claimant has closed his case or about to close his case?
I take it that perhaps what is intended here is the statement of defense. But if it is a statement of defense, it has to have been filed within time, and it is unlikely that the claimant will have been allowed to begin to call evidence if the time allowed for the defense had not lapsed. And if the time had lapsed, the only way he will file his paper validly is that he will have sought leave of court to do so. So in all cases, he cannot just come and file at any time he desires, And it is unlikely that the hearing will have commenced when his time to file his pleadings had not lapsed. So that scenario may really be difficult to contemplate. Yes.
Okay, I think Anene is asking a similar question in another, he says the question is in respect of amending the statement of defense after the claimant has closed his case. What if the amendment is aimed at reflecting the evidence that may have been elicited in the course of cross-examination of the claimant or witnesses called by the claimant in the course of proving his case?
Oh yes, it's seeking leave to amend to harmonize your pleading in line with the evidence already adduced is a familiar ground for allowing amendments. If that is the reason you're asking to do that, the evidence will already have been in, and I imagine that the courts may be hard put to refusing such an application. The only grounds usually when the court may not allow that after the close of the case of the adverse party is that it will be unfair to allow you to now bring in new facts when the other party will have closed its own case. But for harmonizing it with evidence already adduced, the court will probably allow that, yes.
Okay, Raphael is asking the same question about amendment is similar. So Ogechukwu is asking, please, on the issue of amendments and the processes accompanying them, how would a visiting counsel know the attitude of the court he would be appearing before for the first time? Are the rules of that court enough?
Well, the rules will not, the court will usually be bound by the rules that regulate its proceedings. Now, the individual idiosyncrasies of the court are what you may not discern by merely looking at the judge. But the chances are that the day you start the trial may not necessarily be the first time you are appearing in that court. And it is also prudent. You must have colleagues. You know the judge's usual disposition to some of the things, the way he does his things. So it is prudent for a counsel. They say, know your judge. That is one of the first things that you do. You don't do that by coming to say, it's my first time of coming. Oh, you do get some concessions when you say, my Lord, it's my first appearance before you cut me some slack here and there. You get away with certain things as opposed to somebody who is supposed to be familiar with him. But it can also work hardship on you. So you have to be proactive in what you do. But the judge will be bound by the rules of court, which regulate his procedure. But whether he allows you concessions to come when you come late, he doesn't strike out your matter and all that, those are things you have to weigh.
Okay, I don't know how much longer we have for this session, but this question is very interesting. The law, Isaac is asking, the law strikes that a counterclaim is an independent action. It is equally the law that actions are commenced by filing a competent writ. Thus, in a situation where a counterclaim was filed by a defendant, but the writ of someone was found to be incompetent and therefore struck out by the court, what would be the position of the counterclaim given that there is no writ upon which the counterclaim will rest?
I am certain that somebody had earlier asked this question. But the thing is this, once you recognize the separateness and the independence of both actions, and that factually the counterclaim does not necessarily rest on the writ of summons, it may have arisen from a case initiated by a writ of summons, but it develops a life of its own, so that the fate of the claim may not necessarily adversely affect the counterclaim. So, just as I said earlier, my view is that the fact that the counterclaim is adjudged to be either incompetent or unmeritorious, the main claim may not necessarily impact negatively on the counterclaim if it otherwise has no issues of its own. So it should be able to go ahead and plead, because it will otherwise has potentials for working hardship on the defendant. if he's taken out at that stage and the statute of limitation will prevent him from coming again, that will have been unfair to him for no fault of his. Okay, so that's what I think.
Mr. Rojikwe, how much time do we still have for questions? Because there are so many questions in the. So should I take 2 or 3 more? Okay, so
you don't have time for the questions.
You don't have time at all.
Okay.
I think we'll try and crop the questions and see what we can do with them later on. But
Okay.
very quickly, I'd just like to know whether any of the faculty members, in fact, I'll allow the ones present a minute just for comments before we move to the next session. And I'll be starting with Mrs. Essien, Senior Advocate of Nigeria. Madam, any comments from you on the lecture?
No, I mean, Mr. Mosier, Essien, or shall I say Uncle Kenneth?
That's Tobena's creation.
You send pocket money to me. Uncle Kenneth has done an excellent job, so I don't have anything to add.
Thank you very much.
Thank you. I see that Mr. A.B. Mahmood San, past president MBA, is on. Sir, please, do you have any comments?
No, just to congratulate you all for putting this together, and also to congratulate my brother Ken for an excellent job. So I've listened to the presentations and the very interesting questions. I think all have been a very worthwhile endeavor. So well done, my brother Ken, and well done to the team.
Thank you very much.
Thank you, sir.
Yeah.
So I will, Mr. John Bayesia. Sir, do you have any comments?
Just to commend you for the good job you are doing, and to also say that I concur entirely with all that Mr. Ken Mosier has done and has said. The presentation is well made. We have all learned something new. Thank you.
Thank you very much.
Bayesia, in addition, must come back with something, wherever you are.
The only thing that is here is COVID-19, and we have passed it.
No, don't bring that one back. We don't want. Don't very out of it. You're welcome. We'll put you in quarantine if you bring it back.
All right.
Thank you.
We also have Mr. YC Mikhail, Senior Advocate of Nigeria. Any comments, sir?
Well, just to join others to say that Uncle Kenmo did a wonderful job of what he was asked to do.
So
it was quite a delight listening to the delivery on the subject and the questions that followed. Quite illuminating as well. And to also say a big congratulations to you, Tobena, for a wonderful job, putting this training, and you can see the yearning, to learn from our colleagues and their readiness and openness. Very, very encouraging and well done.
Thank you very much.
Thank you very much.
Yes, thank you very much, Mr. Ken Mosier San, for a very illuminating lecture. We all learned a lot from you today. There are some interesting statistics that I would like to share very quickly before we move on. First of all, just looking through the chat box, it's interesting to note that we have a cross-section of Nigerian lawyers from different disciplines, from the academia, from the corporate world, from the public sector. I also acknowledge the presence of Mr. Sani Garungaba San and Mr. Chief Godiuche San. Welcome to the sessions. Yesterday, we had a total registration of about 5,600 people with 2,437 attendees. That is quite remarkable, and we hope that people take away meaningful lessons from these lectures. So thank you very much. We will now go to the second presentation for today. We'll be looking at preparation and service and appearance, supporting evidence for hearing, service, and appearance. Our speaker would be Kelechi Waiwu Esquire. Kelechi is a litigation lawyer. He's the head of advisory board of chambers of Amechi Nwiwu, San and Co. and the managing counsel at KGBC Legal. Both are purely litigation-focused law firms with offices in Abuja and Umuahia. He holds a Bachelor of Laws degree from Abia State University and a Master of Law degree from Obafemi Awolowo University, Ile-Ife. He was called to the Nigerian bar in 2003, and he qualified as a solicitor of England and Wales in 2010. Kelechi is a member of the Nigerian Bar Association as well as a member of the Law Society. Kelechi has been in practice for about 18 years and practiced as a solicitor in England and Wales for 6 years, until assuming the role of head of advisory board at the chambers of Amechi Nwiwu, Senior Advocate of Nigeria and Co. He was the managing partner at Jemek Solicitors, Birmingham, United Kingdom, a litigation and commercial transaction law firm. Kelechi's specialties include, but are not limited to, dispute resolution, litigation-based, criminal defense, and appellate practice and procedure. I have the pleasure of welcoming Kelechi Nwiwu. Kelechi, please.
Thank you very much, Tavinda. And I'd like to, first of all, say good afternoon to all the learned senior advocates, members of the inner bar, and all members of the outer bar. I count this as a privilege to be selected to present this training this afternoon. I would like to thank the NBA-ICLE Civil Litigation Training Team. Now, I've been directed today to cover two main areas. One is supporting evidence for hearing, and with regards to that, we'll be considering the witness statement, the relevance of a witness statement, the relevance of an affidavit, distinctions between the two of them, how they are prepared. Also, we'll be considering supporting evidence, what sort of oral or documentary evidence a claimant or a defendant will require in order to present his case. Then I would also consider ensuring that evidence is obtained and presented in admissible form. We'll be having a look at list of witnesses, list of documents, affidavit of non-multiplicity as used at the Federal High Court. We'll also be considering service and appearance. Now, kicking off with supporting evidence for hearing. First of all, I would like to approach this topic from the perspective of oral and documentary evidence. Now, with regards to the oral evidence, the first document I would like us to look at is affidavits and witness statements on oath. Now, for witness statements on oath, they are normally, as we all know, used for proceedings commenced by way of writ of summons. And then for affidavits, that can be used for a motion, an interlocutory motion, an ex parte application, or originating summons, a suit that is commenced by way of originating summons or originating motion. Now, with regards to their preparation, in preparing these two documents, it is advisable to consider the relevant sections of the Evidence Act. And I would recommend sections 107 to section 120 of the Evidence Act. Now, this sets out explicit what one must take into account when preparing an affidavit. Now, though the Evidence Act does not specifically refer to a witness statement on oath, but a case law that can be a guide for us to ensure that we prepare witness statements just like we prepare affidavits is the case of GTB PLC and Abiodun. Citation is 2017 LPELR 42551. It is a Court of Appeal decision. And in that case, the Court of Appeal found that statement on oath or affidavit must comply strictly with Section 13 of the Oaths Act laws of the Federation for it to be valid. Basically, it must be sworn before a commissioner of oath. And if it must be sworn before a commissioner of oath, then we are bound to actually look at the Evidence Act and look at how compliance must be met with regards to affidavit, and then ensure that the witness statement on oath is also prepared in that regard. Now, there are certain things that must be taken into account, such as the heading of the statement on oath. It must be headed properly. You don't expect to file an application in a high court or file an originating motion in a high court and then prepare an affidavit that bears the heading of a magistrate court. That will be fundamentally defective to that particular affidavit. Then also, there has to be proper paragraphing of both documents. Any erasures in both documents has to be initial, properly erased, initialed before the commissioner of oath before whom it had been previously sworn. It has to be legible, and also it must be sworn, like I said previously, and it must be signed. So a guide for us in that regard is Section 117, I think, of the Evidence Act. So when you're preparing your writ of your witness statement on oath, obviously you've taken instructions from your client. You have prepared your pleadings. As you're preparing your witness statement on oath, which ought to be filed as one of the originating processes in a matter commenced by way of writ of summons, as much as it is possible, it is advisable to ensure that the facts that are set out therein to a very large extent reflects the statement of claim and the statement of defense. Because a very smart defense counsel at the address stage can argue that the evidence as set out in the witness statement on oath is at variance with the pleadings. So, and that would also, get the court to either not regard the evidence that is before the court. Now, it is important as well to mention at this point that the witness statement on oath takes the place of evidence in chief. Now, most practitioners that qualified and practiced before the new rules of front-loading will recall that practitioners would always have issues in court with witnesses who would either forget what they have pleaded in their statement of claim, and they will veer off completely from the witness of from their statement of claim, and you would hear the judge admonishing counsel, please could you lead your witness in chief, lead him in chief. And at the end of the day, you realize that so much time has been wasted, too much time has been taken in conducting examination in chief. Now, with the introduction of the witness statement on oath, everything the witness would have said by way of oral evidence in court is then reduced in that witness statement on oath. It is sworn before a commissioner of oath. Now, at the point in court, once he adopts that witness statement on oath, it becomes evidence for which the defense counsel or the defense can cross-examine. And the outcome of that cross-examination, together with the adopted witness statement on oath, becomes oral evidence before the court, which the court can rely on in making findings in that particular claim. So it's important that every fact that you intend to rely on is actually set out in that witness statement on oath. Now, you've got your oral evidence, whether it is by way of proceedings commenced by originating summons, you've got it. Your affidavit is evidence on its own. You do not need to call a witness unless there are varments. It is a very, very contentious suit which cannot be resolved by way of affidavit evidence. Then the court can direct for pleadings to be filed and for witnesses to be called. Now, moving on, the other supporting evidence, the question then the lawyer must ask at that point is, what documents do I need to prove my case? So if your client comes to you and says, well, I was employed by XYZ company and subsequently my employment was terminated, obviously their alarm bells should ring that you need two very important documents. One is the letter of employment, and the other is the letter of termination. So once your client is reeling out facts to you, it's at that point that we are expected to identify the nature of evidence that is required. Do I need any documents to be produced to support the facts that are going to be put forward before the court? Do I need, if my client is claiming that he was hit by a vehicle and he's suing the owner of the vehicle, suing the insurance company, do I need medical evidence? Yes. Do I need any other evidence that will support that this incident actually happened? There are pictures that were taken. Is there a video recording of the particular incident? Is there a CCTV video? All this evidence must be taken into account in the preparation of the case. Now, moving on then, the question is, how do I get this evidence? From whom do I get the evidence? Now, for me, there are three major sources from which a practitioner can secure evidence to assist his client's case. Now, I know we have so many experienced senior advocates listening to me today, and I'll be happy during the question and answer session if they can also pitch in to suggest some areas that I have not adverted my mind. Now, the philosophy is that the client is the master of the facts, while the lawyer is the master of the law. So the client should be able to make available all the documents in support of his case. Now, it is important that these documents are seen, they are cited before the pleadings are even drafted. you've seen the documents, you understand their forms, their nature. Are they documents that can easily be tendered without having them certified? Are they public documents? Are they private documents? Is it primary evidence? Is it secondary evidence? So at that point, those documents must be analyzed. But yes, your client should be your first source of obtaining both oral and documentary evidence. Now, what is the second source? Now, the second source for me is the defendant. Yes, if you are a claimant, you can obtain whether orally or documentary evidence from the defendant. Now, there is a procedure in the High Court rules, which most of the times it is overlooked, but it is virtually in all of the High Court civil procedure rules in all of the states where we practice. Now, one is discovery and inspection. Now, the High Court rules provides for this procedure. For instance, if there are documents or any evidence you believe that is in possession of the defendant and which you believe that is impracticable for them not to have access to such a document, then you can file a motion seeking an order of court for such documents to be made available for you to carry out some inspection and discovery. Now, the provisions are there in our High Court civil procedure rules. Also, when you look at the back of the High Court civil procedure rules, you'll find the forms. And with those forms, you would be able to tailor and tweak any motion that you'd like to file in that regard. Now, the second is by delivering interrogatory. So if you find that a defendant is being less than truthful with regards to certain facts, and you believe that you might have access to information as well that might contradict the defense, then you could deliver interrogatories by way of filing a motion as well to the court requesting that that the defendant or any particular witness of the defendant or any other person in the defendant's organization should answer to the questions as set out in the interrogatory. Now, so we've learned that you can obtain from your client, you can obtain from the defendant. Now, the third for me is any other person whose evidence, whether oral or in possession of documentary evidence, that will be helpful to your client's case. So by way of a subpoena, they can be subpoenaed to come and tender any documentary evidence, or they can come to give oral evidence which you believe would assist the court to come to the just determination of the case before the court. So having considered the sources of how we can secure oral and documentary evidence, the next document I believe we should consider, which forms part of the originating processes to be filed if a suit is being commenced by way of writ of summons, is the list of witnesses. So the list of witnesses should set out all of the witnesses you intend to call. Now, you set it out, preferably, there's no hard and fast rule on how you set it out. It mustn't be in the order that you intend to call the witnesses, but as long as you set them out, but also you are not bound in any way to call all of the witnesses that you have set out in your list of witnesses. Once you're of the view that a certain number of witnesses have established your claim, you can jettison the other witnesses. Now, the other document that is also necessary and imperative is the list of documents. Now, when I read the High Court Civil Procedure Rules for Abuja, I discovered that there is really no requirement for us to file a list of witnesses. Now, what the rule provides for is for the list of documents. There is no requirement for a list of documents like you have list of witnesses. What the rule requires is for documents which will be relied on in the case. So the issue of a list of documents, in my view, has evolved over time as a form of good practice. Yes, it has evolved as a form of good practice. So, and it's quite interesting to note that most of the times, you find that the list of documents is not really prepared in such a way that it will be helpful to the court and to the counsel on the other side, as well as the counsel that is presenting the case. So we have some of our colleagues who model up the documents. It's always important to arrange your documents in the order you have listed the documents. Let me give an instance. For instance, if you have about 30 documents, you have maybe an oil spill case where you have loads of documents that you have front loaded, it's very, very important to list it in the order that you intend to tender it. Now, during the trial, it might be difficult for you to take all those documents one after the other to tender them, because the counsel for the defense or the counsel on the other side will obviously want to take objections to the admissibility of some of those documents. Now, depending on the court where you are conducting your suit, some courts would prefer to sort out issues of admissibility of documents at the pre-trial stage. So at the pre-trial stage, all of the parties filed, they've already filed their list of documents. Then at that stage, it is resolved which documents you're objecting to and which documents you're not objecting to. But there are some courts that would prefer to take up the issue of admissibility at the stage of the trial itself. So imagine going through trial. You have about 30 documents and you're taking them one after the other, and objections are being taken seriatim. Obviously, at the end of the day, you're going to spend a very long period of time in order to tender all your documents. So what I'll advise is you can respectfully appeal to the court and apply to the court for the court to adopt your list of documents, in the order that you have front-loaded the documents. And for the defendant or the other counsel on the other side to simply identify from the list the documents that he does not intend to object to and those he's objecting to. And then the court will admit the documents that he's not objecting to. And then objections will be taken on the documents he's objecting to before the court will make a composite ruling on the issue of objection. So the list of documents is very, very, very important in the course of a trial. Now, the other document you'll be preparing is your certificate of pre-action counseling. Now, that document obviously states that you would have advised of his case. You've advised him on the availability of ADR, and also you've advised him on the possibility of reconciliation, as well as you are aware that where the suit is found to be frivolous, that you will be liable in costs. Now, you can imagine when such a document is not filed and it's overlooked, not filed, and your client's case is dismissed, and the court makes comments and strictures as regards to how the case has been presented, and the court makes findings that the suit is frivolous, a waste of judicial time. Your client could be in a good position to claim for damages. Yes, he can. So it's important that that is properly set out, filed together with the originating processes. Then there is the affidavit of non-multiplicity of that can be found in the Federal High Court. That was also introduced to curb forum shopping and abuse of court process, where some individuals may come to Abuja, file a suit, go to Enugu or anywhere in the north, file another suit, incurring the cost to make judgments or rulings on a particular issue twice, raising confusion as well. So it's important that that is also filed. So that is it for supporting evidence for hearing. Now, the other point I've been asked to look at is service of your process. Obviously, the High Court Civil Procedure Rules makes provision for the issue of service. The question then is, what time should originating processes be served? In some jurisdictions, a writ of summons is to be served within 3 calendar months from the date of issuance, or if renewed, within 3 months from the date of the last renewal. That is the position in the FCT. With regards to Lagos, a writ is to be served within 6 calendar months from the date of issuance, or if renewed, within 3 months from the date of the last renewal. So this is a potential preliminary objection point. Once a writ is received, it's important to check at the bottom bit when it was issued to know whether it was actually served within time. Now, the other point I've been asked to look at is the proper mode of service. There are 2 forms of service: personal service and also service other than personal service. Now, with regards to personal service, obviously, the process is expected to be served on the individual personally. Mr. XYZ is served the process is served on him as a person. Now, there might be issues with service. At times, you've had some bailiffs coming back to say there was violence or I couldn't serve. Obviously, the rule provides that in such an instance, even throwing the process at him or leaving it as nearly close to where he is will be deemed as proper service. Once the bailiff prepares an affidavit of service and puts it in the court file, that will be sufficient. There is service other than personal service, for instance, serving a minor through the guardian. There is also provisions in the rules for how prisoners should be served. Lunatics in the asylum, by delivering it to the officer in charge. For corporate bodies, you have to look at section 78 of CAMA, and then the High Court Civil Procedure Rules for service on principal officers or living at the place of business as well. With regards to suing a law firm or suing a firm of accountants, serving on any of the partners is sufficient. Or if the firm has been dissolved to the knowledge of the claimant before the commencement of the action, the origination process shall be served upon every person within the jurisdiction sought to be made liable. Now, with regards to service on employee of government, that could be served on a senior officer in such a ministry. Substituted where you have to come before the court by way of an ex parte application. For instance, let me give a usual one, which is, let's say Mr. A and B are engaged in a civil agreement. Now, Mr. A defaults and Mr. B, instead of suing him in a civil action, runs to the EFCC to use the force of the law to recover the funds. And you have a little window within which your client was granted bail, and you decided to file a suit, and you file that suit, but you're not maybe aware of the whereabouts of the other party. You can bring an application for substituted service of the court processes through the EFCC, through whom the other party can come to the knowledge of the existence of the suit. So that can be filed in court and obtained. What is the effect of non-service? It is extremely fundamental, because without service, the court can't assume jurisdiction to entertain a suit. Without service, the court can't assume the jurisdiction to entertain a motion. So service is extremely important. Now, there have been instances where judgments have been set aside, proceedings have been set aside as a result of non-service. So assuming you are in the office and your client comes to you with an order of court, and you were not aware that there was a hearing and an order was made, what do you do? In my view, the first thing to do is to make an application to conduct a search in the court's file. It's not sufficient to simply file an application to set aside the order to claim you were not served. No, there could be an affidavit of service in the court file. So an application to the court for a search of the court file should be made. When that application is granted, then a thorough search should be made in the file to discover whether there is proof of service in the court's file. Now, if there is proof of service, then you have to think around what else to do. But where there is no proof of service, that should form the basis on which you bring your application to set aside the order or any proceedings conducted in your absence. For appeals, for instance, most of us are aware that most appeals, most of the times, are not even entertained where there is no service. We've seen instances where someone has waited for 2-3 years to have an appeal heard. And obviously, at the end of the day, you have a hearing notice served on you and the other party is not served, and you have to wait another 6 to 12 months before you come back. Moving on to service outside of jurisdiction, that was adequately dealt by the Leonard Sale, Mrs. Akeredolu SN yesterday, so I wouldn't really be delving into that. Then there is proof of service. How do you prove service? If you undertook to serve, then you'd be expected to file an affidavit of service after you have served, disclosing the date, the time, the place, and the mode of service. Now, if you use the bailiff to serve, then you'd chase up the bailiff to ensure that the bailiff had prepared an affidavit of service and had put same in the court's file. Now, when the defendant is served, what does he do? Well, he would have to look at the rules to understand when he has to enter appearance. Order 15, Rule 1, Subsection 2, Abuja High Court Civil Procedure Rules gives a period of 21 days for the defendant to file the processes that he's meant to file. For Lagos, it's 42 days. I don't know why Lagos always gets more days than us in Abuja. We would have to look into that. So 42 days to file their defense and other processes. Then Failure for the defendant to file his processes within time leaves him in default. Obviously, you'd have to then pay default fees, without which the court wouldn't hear you. Ex parte applications, when not to file ex parte applications. Now, I've not been asked to delve deeply into ex parte and applications on notice. It just says when not to serve ex parte application. But looking at that, let me start with an experience I had in court today, very, very briefly. This morning, one of our colleagues had filed an application to set aside an ex parte application made by the courts. Now, his grievance is that the other party had filed an ex parte application, and in the order had prayed the court for an interim order pending the determination of the substantive suit. An interim order, ex parte, pending the determination of the substantive suit. So his grievance was that obviously interim applications ought not to last more than 14 days. So, and no motion on notice was filed together with the ex parte application. And an ex parte application ought not to be made to last till the determination of the substantive suit, because you have not heard the other party, you have not heard of the other party on notice. So his argument was that the court should set aside the order already made, because he was not heard. No motion on notice was filed together with the ex parte application, and the court in error made the judge the order. And I'm in agreement with him, because ex parte applications are made to last just for a short period of time, for you to preserve the rest, more or less to preserve the rest. And there has to be a return date, a very short return date, within which the other party will be put on notice for him to have his say in court, before the court can then either dismiss, vacate the ex parte order, or then hear the motion on notice and then make it to last to the determination of the substantive suit. So whenever you have an urgent application, an urgent need to preserve the rest, a building is meant to be demolished, your client is about to be arrested, or some funds in a particular account are about to be depleted. So it's important to file together your ex parte application together with your application on notice. Most of the times, the judges would give a very short period, will not grant the ex parte application, but then give a short period for all the parties to come to court, and then take the application on notice. Moving on to appearance. What do I do? I've been served with the process. What do I do? You need to enter appearance. The court procedural rules provides for time to enter appearance. For Lagos, it is 42 days. Once again, they have a longer period than Abuja, which is 14 days to enter appearance. Now, where you are, or before I look at where you're out of time, let's consider the mode of entry of appearance. For the mode of entry of your appearance, obviously you're meant to file your memorandum of appearance. If, for instance, you don't have all of the issues with which you intend to file your statement of defense, obviously the rules gives you a separate period of time within which to file your statement of defense. But if you're out of time to enter appearance, you can still bring an application for extension of time, seeking for time to enter appearance. That application has to be brought on notice with an affidavit and a written address. I think I have covered the field with regards to the topic I've been asked to present. Once again, thank you for this opportunity to make this presentation. Thank you.
Thank you very much, Kelechi, for what I think has been quite an interesting lecture. Thank you very much. I'll now invite Ms. Nta Ebiken to take us through question and answers. Thank you. Nta, please.
Okay, thank you, Tobena. So good afternoon, everyone, again. And just before I go on to the questions, please, I just wanted to remind us that there won't be any training tomorrow. We apologize for any inconvenience. So please, if you have any questions, just post them in the Q&A section of your screen. And I'll just start with a question from Mrs. Badejo Ogunsoya. Is it not the law that a witness statement is not invalidated simply because it was not sworn before a commissioner for oath? Put in another way, since a witness statement does not become evidence until it is adopted in court, why must it be sworn before a commissioner of oath when it must be adopted in court before it is used? Courts have held that a witness statement is not the same as an affidavit, which must be sworn before a commissioner of oath. Did you get the question, sir?
Yes, I get the question. Well, like I said, making reference to the case of GTB PLC at a building, the Court of Appeal found that a statement on oath or an affidavit must comply strictly with Section 13 of the Oaths Act. Unless there's any other decision other than that, I don't know about.
Okay, so Solomon is asking, must a motion or notice be filed alongside an ex parte application in a proceeding beginning by originating summons? Do you want me to take that again?
Yes, go on.
Okay, so must a motion or notice be filed alongside an ex parte application in a proceedings which began by originating summons? I think that's what he meant.
Now I'm assuming that there is an urgent issue the council intends to address the court on. And if it is urgent, it makes for good practice. It only makes for good practice for your motion. For instance, if it's a motion for interlocutory injunction, it makes for good practice. And then the judge also sees that you are serious. You're not just coming to get an ex parte application and then go to sleep. No, you are showing the court that you are desirous to address this particular issue. So it is advisable for you to file your motion on notice for interlocutory injunction together with your ex parte application for an interim order of injunction. It is advisable to file both of them together.
Okay, so Nkiruka is asking, please, can a document made by a deceased person be tendered by another during trial?
Can a document?
Yes, made by a deceased person be tendered by another during trial?
Well, that, first of all, that is not an area that I was asked to
exactly. I'm sorry about that.
to present on.
Okay, so
but my view really is
sorry, sir. Hello. Hello.
He appears to be having connection issues. He was on mute for a bit.
Okay.
If it is relation has been made, there's no reason why you can find. Hello.
Oh, Yes, you just got back, sir. So I think you're going to.
Okay, so did you get that bit?
No, we didn't get that.
Okay, so what I said is, what I said is, if the document has been pleaded, if it is relevant to the proceedings, and the necessary foundation is laid whilst tendering the document, there's no reason why the court shouldn't admit it and rely on it in making findings in the case. Relevant is the crux of admissibility.
Okay, I guess when we're going around to ask comments from any other faculty member, we'll be able to actually add to that. Ehumole is asking, substituted service by publication in national paper was ordered by court. It was complied with, but before the adjourned date, Justin went on strike. A new date has been taken. Now, will the plaintiff be required to serve the defendants, to serve the hearing notice through another publication? Through another publication in a national daily newspaper. Did you get that, sir?
Yes, but I think what you should actually look at is what was the order of court in the first instance? Did the court say for the proceedings and all other processes to be served by way of publication in a national daily? So if the order of court covers all other processes, all other subsequent processes, if you know of their whereabouts, you can go ahead and serve, but where you're not aware of their whereabouts and the order covers all other processes or hearing notices in the suit, it's important how we draft our applications, the prayers that we're seeking from the court. Then obviously you have to go back and make the publication.
Okay, so the two questions are similar, so I'm just going to ask both of them
together. Let me add some other thing. Let me, okay, go.
Oh, sorry, you can add, or we can come back to it later. Or did you want to add something
what I
else?
wanted to say is, yes, what I wanted to add is, with regards to service by way of publication, especially when you're conducting a matter in the Federal High Court, it's important to, instead of using publication, depending on where the person is. If the person is within, Abuja, for instance, it's important to ensure that the newspaper that you are using is maybe one that is local to the place where the person is, and you have to also make inquiries as to costs, because it can be very costly to make newspaper publications. So the other option might also be to ask for substituted service at a local court house by pasting at a local courthouse, maybe where you believe the person might be in, that might be an option for you, more or less.
Okay, so Rachel is asking, where an order for substituted service has been gotten from the court to serve a respondent via 2 email addresses, and delivery of one of the email addresses failed because the address could not be found by Google Mail, is it advisable to cease effecting service through that mail? That's one question. And then a similar question to it is, what is to be done if there is a purported proof of service, but the client has not received same? Did you get that, sir?
Now, it broke off at some point. I do apologize. It broke off at some point.
So the first question is about email addresses. So it says, where an order for substituted service has been gotten from the court to serve a respondent via 2 email addresses, and delivery of those email addresses fail, is it advisable to cease effecting that service through mail? That's one question. Then the second is what can be done if there is a purported proof of service, but the client has not received same. So there are two similar questions.
I mean, if you try to serve someone, you can't reach him, you look for another mode of service. The learned senior advocate Akere Dolu yesterday mentioned service by WhatsApp is possible. Service by SMS is possible. So there are other, once you try a particular pathway, it doesn't work, you reinvent yourself, reinvent your strategy, and adopt a different form instead of allowing your case to be stalled. If the person says he hasn't received it, I'm not. If the person says he hasn't received it, is it a hearing notice? Is it an originating process? But he has already instructed counsel to represent him and then come to court and say that he hasn't received the service of the process. Well, I'll leave that to the judge to make the finding on that.
Okay, Bankole Shodipo is asking, can you throw some light on the confusion whether service of originating processes on corporations must be made at the head office or branch office or registered address?
Well, with regards to, yes. I got that. With regards to corporate bodies, let me just read out Order 7, Rule 8 of the High Court Civil Procedure Rules, Abuja. It says, subject to any statutory provision regulating service on a registered company, subject to any statutory provision regulating service on a registered company. Now, obviously, with that, CAMA should come in mind, okay? Now, and CAMA section 78 says a court process shall be served on a company in a manner provided by the rules of court, and any other document may be served by leaving it at or sending it by post to the registered office or head office of the company. So what I advise you to do is just read section 78 of CAMA and order, the order in your jurisdiction, which provides for how service should be effected.
Okay. Okay, so on what circumstances can a person who is not a maker of a document tender a document, bearing in mind that the said document is a public document? Did you get that, sir?
That wasn't part of mine.
Exactly, I didn't think so. Okay, so
yeah.
Ahmad is asking that affidavits and witness statements on oath have one thing in common. That is, they must be sworn before a commissioner of oath. What will happen to an affidavit of witness statement on oath that was sworn before a notary public due to the fact that the court staff is on strike?
If it's a court process, and in my view, I mean, this question about strike is coming up because we're just coming out from the recent strike. So I don't have any authority to that, but in my view, if it is a process that is meant for proceedings in court, if it is meant for proceedings in court, obviously the registry is closed. Why would you go to a notary public to prepare an affidavit or a witness statement on oath for a matter you are for a process you intend to use to conduct a proceedings in court? So if we have a case law, like I said, GTB PLC, which says that section 13 of the Oaths Act must be complied with regards to statements on oath and affidavit, then such a process for the purpose of proceedings ought to be rendered invalid. That's my view.
Okay, Torcha is asking, where the defendant's location is not known and the plaintiff/claimant comes by way of substituted service via a motion expertise, and particularly praise the court to serve all originating and subsequent processes on the defendant via substituted means. Would the expertise order elapse within a short period of time? That is, does it mean that the order cannot survive the entire suit until judgment? Are you there, sir? Did we lose him? Hello? Okay, I think his internet
Hello,
is having.
sorry.
Sorry, did you hear my question?
Sorry about that.
Okay. So do I repeat the question again?
Please, please, please.
Okay, so the question was, where the defendant's location is not known and a plaintiff/claimant comes by way of substituted service via a motion expertise, and particularly praise the court to serve all originating and subsequent processes on the defendant via substituted means. Would the expertise order elapse within a short period of time? That is, does it mean that the order cannot survive the entire suit until judgment?
Well, once you obtain such an order and the process has been served by substituted means, pasting, whatever means, and the defendant retains counsel and appears in court, I mean, automatically that has elapsed. You know, you simply serve counsel. You serve his lawyer who is in court. So it's immaterial, you know, what happens to it and whether it lasts till, I mean, if you have counsel in court, you wouldn't be expected to go and serve someone else or serve by pasting or serve by newspaper publication when you have counsel in court. So it becomes immaterial, more or less, once the defendant has retained counsel as and is in court.
Okay, so Grateful Pepper is asking, must all motion expertise be accompanied by motion on notice? What about the case of arrest of vessel or Mareva injunctions or antampila orders, which is often obtained expertise? Is it not the respondent that should file an application to set aside or vary an order for arrest or attachment of certain assets?
Whatever works for you, do it. Like I said, if you believe, it depends on the nature of proceedings at the end of the day. It's down to the nature of proceedings that you have before the court. Like I explained, if it is a very contentious issue, let's say, for instance, you got an information that a huge amount of money is meant to be removed from a particular account. And it is a very, very contentious issue, which is not known all over the country, that it has to do with maybe a particular company that is engaging in a massive contract, and where such an order will also affect such a company. The court must balance the interests. The court must see the seriousness of the party that is bringing the application, the ex parte application. The court would want to know. I hope you don't get this and just go to bed. So there is no hard and fast rule about it. Like I said, it is advisable to file it along depending on the nature of your action.
Okay, so I'm just trying to limit the questions to the subject matter. So I'm just trying to limit. So Ibrahim is asking, what's the legal implication of a motion ex parte filed to restrain the defendant pending the determination of the suit, but the suit has not been assigned till after 6 months and the defendant is still building on it? What is the effect of the case? What is the effect of the case if subsequently assigned? And that's what he meant to say.
Now, like I said, it's wrong to couch an order in an ex parte application seeking for an order interim. Remember that an ex parte application is for an interim order of court. You cannot use an ex parte application for an interlocutory order. An interlocutory order lasts till the determination of the substantive suit, and it must be brought by way of a motion on notice. An ex parte application can be brought to last till the determination or hearing of the motion on notice. So that is why I said it is important when you file your ex parte order, you also file your motion on notice. It will be unfair for the court to hear an ex parte application behind a party and make an order that will last till the determination of the substantive suit without allowing that party to have a say on it. So there are two different things: ex parte order for an interim order of court, and then motion on notice to last till the determination of the substantive suit.
Okay, so Oluchi is asking, my understanding is that an affidavit of service is not conclusive proof of service, but is rather an assumption that the service was made. Isn't this the provision of the law, such that the defendant who was not indeed served or properly so served can apply to set aside the affidavit of service and make other prayers, e.g., setting aside of the court order as the case may demand?
Well, like I previously said, if you're having any issues on service, the first step is to make an application for a search in the court's file, obtain whatever affidavit of service that is in the court's file, have a look at it, know whether it complies with. Let me give you an instance. If the court made an order that substituted service should be effected by way of, let's say, newspaper publication, and somebody goes to serve a gate man, or let's say, for instance, service to be effected on a company, on the principal officers, and then the service is effected on the person who signs the process from the bailiff, puts down his name, and his designation is the gate man or a driver. The court can set aside the service because it doesn't comply with Section 78 of CAMA and the High Court Civil Procedure Rules. So you need to look at the affidavit of service. If you question it, then you can file your application and set out in your affidavit in support of your application reasons why you believe that service was wrongly effected.
Okay, so Ibrahim is asking, can an originating process served on a defendant's corporate body in her registered address outside jurisdiction without seeking a leave of court, although the defendant's branch office is within the jurisdiction, but it's closed.
Sorry, can you come again? If what?
Can an originating process be served on a defendant who is a corporate body in her registered address outside jurisdiction without seeking a leave of court, even though the defendant's branch address is within the jurisdiction, but it's closed?
If you have to seek leave, go ahead and seek leave, yes. Seek leave of court and then go ahead and serve them outside of jurisdiction.
Okay. He's asking, looking at the provisions of Section 78 of CAMA, will it not be proper to serve a principal officer of a company anywhere he is seen in Nigeria other than the registered office? Can the said court process be served on the principal officer where he is seen attending a party in Owerri, whereas the registered office of the company is in Abuja? Will the service be proper?
If he's a principal officer and you give him the process and he accepts it, he's a principal officer. I don't think the interpretation of CAMA says that the principal officer must be in the registered address when he's being served. He's a principal officer. As long as he's served, there's proof of service. For me, it is good service.
So I think that's okay. So Blessing is asking, after the time frame for an interim order has lapsed, is there need to bring any other application by either party, or does the order just lapse?
Well, it depends on how the order was couched by the court. For instance, if the court is quite specific to say this order will last for 14 days, I hereby give a return date of so and so date. Then if the court is specific in the order for how long it's going to last, then it goes off thereafter. But where it is not very clear, yes, it is meant to last for about 14 days. But where you feel that actions are being taken beyond that 14 days by the other party, then you can approach the court by way of a motion and get the court to stop the party on the presumption that the order has lapsed.
Okay, so those are all the questions that relate to the subjects that we were speaking about today. Mr. Ojikwe, would you?
Thank you very much, Nta. Grateful for your assistance. I'll just ask the other members of the faculty for comments before we bring today's session to a close. I'll start with Mr. Ken Mosier, Senior Advocate of Nigeria. Sir, do you have any comments?
Well, the only question I'll probably ask Mr. Nwiwu is where the fact of service of a process is an issue. These days, particularly the superior courts, service is effected by text messages. And my experience has been that all they do is ask the clerks whether they serve, and they will say they sent out a text message. Now, if a party is desirous of contesting the fact of service, would it not be desirable for, say, the proof of delivery of the text message to be downloaded and filed along with an affidavit as prima facie proof of service, as opposed to just asking the clerk to confirm whether or not they sent a text message and he says he affirms? At least that has been my net experience where it was an issue. All they did was ask the clerk, they confirmed that they sent text messages to the telephone number. But I think that perhaps where it is contested, there should be an affidavit of service, attach the proof of delivery of the text message. That should be prima facie proof of service. Don't you think so?
I completely agree with that position. I completely agree. There has to be some form of independent corroboration of that service in that regard. I agree.
Thank you very much, Mr. Mozia. I'll now call on Mr. A.B. Mahmood, Senior Advocate of Nigeria, for comments or questions.
Thank you. Really, just to once again say well done. I've listened to some of the questions, and they're all very thought-provoking and interesting, which Kelechi had responded very well to. But I think it is useful to warn ourselves not to find ready-made answers, to certain questions which would arise in the course of litigation. And it's very difficult to predict, how sometimes litigations will unfold. And there are no ready-made answers. You need to apply your own thinking and, critical understanding of the principles involved, and then try to respond to the situation. So sometimes in conversations like this, we think there are ready-made answers for very tricky questions. So I want to caution against that. I think the important issues in a lot of circumstances is really to understand the fundamental principles involved in some of these difficult situations, and then try to apply your thoughts creatively to find ways around it. So, but I think Kelechi has responded very well to most of the questions, but just thought to add that bit. I know there's a session on critical thinking, which is happening at the last day of the workshop. So perhaps these are issues which can be taken at that time. Thank you again, and very good job. And I'm impressed with the quality of the presentations, as well as the quality of the questions being asked. Thank you.
Thank you very much, sir. Mr. John Bayesha, Senior Advocate of Nigeria, be grateful for your comments.
Yeah, just to commend the presenter for a job well done. I mean, when you sit down there and people are asking you all kinds of questions, you are more or less on a very hot seat, and to think immediately and respond immediately with very helpful suggestions and answers is highly very commendable. And also, once again, to thank the CLE board for all that you are doing.
Thank you very much, sir. Mr. Y.C. Michael San.
Well, just to congratulate you again, Tobena, and also commend Mr. Nwewu for a wonderful delivery on that particular subject that he took, and also to lend my voice to the observation that Uncle Ken Moore made on the issue of service by electronic means, particularly text messages. To also say that it's imperative to actually require proof of delivery of such notice to a client that has been allegedly served, particularly because dealing with these electronic devices, the possibility of abuse is very, very, very eminent. Spoofing is very common, so there would really be a need for a means of establishing the fact that indeed the party has been proved, has been served by such electronic means. Other than that, it's a well done to Mr. Nwewu, and congratulations again to them. Thank you so much.
Thank you very much, sir. Mrs. Essien, Senior Advocate of Nigeria. I thought I saw her pop up a minute ago. Madam, are you on? Okay, in the absence of further comments, Kelechi, I thank you for your time, for the industry and the diligence that you put into this presentation. We are very grateful to you. It was quite illuminating, and indeed, thank you for taking on most of the questions that were asked. As you can see, people already have ready-made questions ahead of time, so, but thank you very much. On a general note, we announced earlier on that there wouldn't be any training session tomorrow as earlier proposed. Trainings will continue on Thursday. We'll circulate further information about this today. I'm very grateful to Mr. Tola Oshobi, who Senior Advocate of Nigeria, who is the interim dean, as we call him, of the faculty, who's done a lot of work putting this together. We're grateful to all the facilitators, Mr. A.B. Mahmoud, Senior Advocate of Nigeria, Dr. Nyechi Bazo, Senior Advocate of Nigeria, Mr. John Bayeshia, Senior Advocate of Nigeria, Mrs. Maya Essien, Senior Advocate of Nigeria, Mr. Saro Ehobamen, Senior Advocate of Nigeria, Mr. Ken Mozia San, Senior Advocate of Nigeria, sorry, San, Mr. YC Mikhail San, Mr. Emeka Nenugu San, Mrs. Abimbola Keredolu San, Mr. Elijah Yakubu Kura-san, Mr. Wole Agumbia Desan, Mr. Abdullahi Yaya, and Mr. San, and Mr. Kelechi Wayu. Thank you very much for your time. And it's not easy to find the time to participate in this kind of enterprise and help putting together course content, and also finding the time to tutor and participate, as scheduled. So thank you very much for giving back to the profession, and hopefully we hope that practice will be better and we would all put what we've learned to better use. We're grateful. Thank you, and see you all on Thursday. God bless you.